What is a Memorandum of Association? A Memorandum of Association or MOA of a company is defined as a legal document that is drafted during the formation and registration process of Limited Liability Company in order to describe its relationship with the shareholders. The MOA is accessible to the public and explains the name of the company, the physical address of the registered office, shareholders' names and the distribution of shares. The MOA and the Articles of Association serve as the company's constitution. The MOA is not applied in the US but is a legal requirement for limited liability companies in European countries, including the United Kingdom, France, the Netherlands, and some Commonwealth countries. The object of registering a Memorandum of Association. The Memorandum of Association contains the object for which the company is formed. It identifies the scope of its operations and determines the boundaries it cannot cross. According to Section 399 of the Companies Act, 2013, it is a public document. Therefore, any person who enters into a contract with the company is expected to have knowledge about MOA. It contains details about the rights and powers of the company. What are the mandatory clauses of a Memorandum of Association of a company? The following are the mandatory clauses of an MOA. Name clause. Registered office clause. Object clause. Liability clause. Capital clause. Association clause. One-person company clause. The company can add additional clauses, such as rights attached to various classes of shares, if required. Name clause. 1. For a public limited company, the name of the company must have the word limited as the last word. 2. For the private limited company, the name of the company must have the words private limited as the last words. This does not apply to companies formed under Section 8 of the Act who must include one of the following words, as applicable: foundation, association, federation, forum, council, chambers, confederation, electoral trust, etc. Registered office clause. It must indicate the state where the company's registered office will be situated. Object clause. It must indicate the objects for which the company is being incorporated. Further, if a company changes its activities which are not reflected in its name, then it can change its name within 6 months of changing its activities. The company must comply with all name change provisions. Liability clause. It must indicate the liability of the members of the company, whether limited or unlimited. 1. For a company limited by shares, it should specify if the liability of its members is limited to any unpaid amount on the shares that they hold. 2. For a company limited by guarantee, it should specify the amount undertaken by each member to contribute to a. The assets of the company when it winds up. This is provided that he is a member of the company when it winds up or the winding up happens within 1 year of him ceasing to be a member. In the latter case, the debts and liabilities considered would be those contracted before he ceases to be a member. b. The costs, charges, and expenses of winding up and the adjustment of the rights of the contributors among themselves. Capital clause. This is valid only for companies having a share capital. These companies must indicate the amount of authorized capital divided into shares of fixed amounts. Moreover, it must state the names of each member and the number of shares against their names. Association clause. The MOA must indicate the desire of the subscriber to form a company. It is the last clause. Before we go to the last point, I would like to tell you that this video is sponsored by rtrsupportslimited.com. RTR Supports Limited can provide UK company and bank account in 1 day. Please visit rtrsupportslimited.com for more information. For one-person company, the MOA must indicate the name of the person who becomes a member of the company in the event of the death of the subscriber. The following aspects are required before submitting the MOA. 1. Print the Memorandum of Association. 2. Divide it into paragraphs. 3. Arrange the pages in sequence. 4. Ensure that at least 7 people sign it, 2 in the case of a private limited company and 1 in case of a one-person company. 5. Have at least 1 witness to attest the signatures. 6. Provide information about the signatories and witnesses such as an address, description, occupation, etc. Thanks for watching. Please share your reviews and ask if you have any questions regarding this video in the comment section below. We'll answer you shortly. Also, don't forget to like and subscribe to our YouTube channel for more such videos.